there's a very good likelihood, Mackenzie, that you will spend the rest of your life in prison.
Southwest attached.
There's a car that's smashed up against the building, and the car's trashed.
The car's split in two. There's an occupant inside. We gotta bust the window out. Now!
29.
Oh my God. Oh my God. Times 3, guys. Radio, 3 occupants. Okay. Right leg. Jesus Christ. Pistol force I've ever seen.
Recording.
Where's she? Right back there, pal.
Hi, Mackenzie. Step out for me. I'm Detective Jesus. I'm the one who's been investigating the crash. You're under arrest for aggravated murder ×2, okay? Nobody's gonna ask you any questions. Nobody's gonna bother you. Can I have your key, please?
Could you please be careful taking this one off so it doesn't break the bracelet, please?
You got it. You got it. No.
Thank you.
You got it. Okay, just keep your hands right here. You're not gonna tighten these, okay? We don't want to hurt you. You good? Are they good? Thank you. All right. This cruiser right here.
Actually, he took her out of the car, and we did not.
Okay. Do you have anything out of anything like that? We're gonna watch your head going in. Don't worry, I'm not gonna hurt you. You okay?
Recording. Mounted. Wi-Fi connected. Recording. Mounted. Wi-Fi connected.
Help me get my foot out. I'm sorry. It's just like.
Stand right by that black mat. Straight forward. Yep. Until that door. Step on that yellow line and just face the wall. I think so, yeah.
Okay. This is the
County juvenile fact sheet.
I don't know why they have like 10 of these. I think they're all the same. Well, no, they're a little bit different.
So just hers. I don't know. He's coming back, I think. 11. Are you gonna come back to the booking room?
Affirm. I'm on the phone with her attorney, Summer.
Copy.
What's your first name? Yeah, I'm talking to you. Okay, Mackenzie, I'm gonna take your handcuffs off. I need like all the jewelry and everything to come off, okay?
I can't wear any of it.
No, I need you to take it off while you're in the jail right now.
I can't wear these.
Now, unfortunately, everything's gonna have to come off right now once we know when the detective comes back and we know for sure what's going on. Everything's gonna be bagged up here. It's not going anywhere.
Sorry, this is just like one of those, which is really hard to get off.
That's fine. Take your time.
What are the green? Are those extensions clips? You're gonna need to
I
take
can't
those
take
out.
them out. They're like in my, like, they're like in.
Okay.
Unless you have pliers, we can get them out.
Necklace, yeah.
What about that tie?
I'm gonna hold off and see what ends
Right.
up. Because it's kind of weird. I don't know. Corvatus is back there. All right, Mackenzie, just hang out up against that wall to your right.
I gotta take her down.
Oh, you're the one transporting?
Yeah.
Oh, okay, that clarifies things then. Because we weren't really told.
Yeah, he wants her to go right downtown.
Okay. That's because we just had. He brought one back the other night. Well, he didn't, but his ag robbery, and they at least gave us a little bit more information saying that they're ready to take.
So I think he called them to verify that they were gonna take her, and they
Okay.
said yes with
Yeah.
the charges. So
We didn't get that information because I know Mace called us and told us a little bit, but not that because there was some confusion because of the age.
okay, maybe it
Which-
changed. I mean, she's 18 now, so
That's the only holdup that we had is we weren't sure if she was going to county or.
well, I think because at the time that well, I'll tell you more, but I don't know if you want to put her in a holding and
No, we'll hold off for,
All right.
let's do that now since. Mackenzie.
I don't know. You're an adult, so as soon as we're done doing what we're doing, you'll be able to make a
Yeah,
phone
we
call.
have to wait for the detective to come back so we can figure out, just have a seat for us.
he left somewhere. Can we take a picture of it and make a picture of it and send it to him? What? Take a good picture of it and send it to him. Alright, thanks.
Okay. We'll take a look.
5-9, make sure that the juvenile fact sheet that gets filled out in the jail is the county one, not the SPD one.
Go ahead.
Yeah, copy that around. You want me to shut straight down 35?
Just pull in front of the road closed so you can
Yeah, I'll do that when I get there. It's gonna take me a minute. Westwood Pro. Tree radio.
Go ahead.
I'm in the area. The caller's still following that car.
That's negative.
This trial is the culmination of decisions made by one person, the defendant. Those decisions have forever altered the futures of 3 families, and of you also, Mackenzie. And your decisions forever robbed Dominic and Davion of the futures that they had before them. If there is one thing that can be taken away from this case, as painful as it is this. Every decision we make is important. Every action we make is important. Regardless of whether the decision is a good one or a bad one, or the actions are good or not, the result is the same. The consequences ripple through time and affect many more people than one might think at the time of the decision. In criminal cases, the state carries the greatest burden under our law, proof beyond a reasonable doubt. As I previously stated, I considered all the evidence presented, and at this point I would like to comment specifically on Exhibit 802, the crash video. This is the type of evidence you can never unsee. You can never forget the visual or audio of this exhibit. It is chilling and tragic. As you review that exhibit, you know that you are watching the oncoming deaths of 2 people, and there is nothing that will stop it. The video clearly shows the purpose and intent of the defendant. She chose a course of death and destruction that day. Exhibit 802 crystallizes the deadly decision-making of the defendant. She morphs from a responsible driver to literal hell on wheels as she makes her way down the street. Mackenzie alone made the decision to drive the car, to drive an obscure route, a route she visited a few days before, and a route not routinely taken by her. Mackenzie alone chose the time to make the drive, early in the morning, when any reasonable person would expect that few people would be nearby to witness it or offer life-saving assistance. She made these decisions despite knowing, as any reasonable person would, that her mission of death could have involved others, not even in the car with her, other people, other cars, pedestrians. She had a mission, and she executed it with precision. The mission was death. Mackenzie alone decided to push the pedal to the floor and demand the ultimate speed of that vehicle to 90 to 100 miles per hour. She alone decided what was to be. Mackenzie decided death was the ultimate goal that day, and she alone made that decision for Dominic and Davion, and she continuously acted in a manner to achieve the purpose. Whether or not she intended to also kill herself is a matter of speculation that have no relevance to the weighing of the evidence in this case. The totality of the evidence clearly demonstrates that Mackenzie Shirilla acted purposely and intentionally in the early morning hours of July 31st, 2022, and her purpose was to kill Dominic Russo and Davion Flanagan. No reasonable fact finder could view the totality of this evidence in this case and come to any other conclusion. Her actions were controlled, methodical, deliberate, intentional, and purposeful. This was not reckless driving. This was murder. Court renders the following verdicts. Count 1. The court, having had count 1 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.02a, is charged in count 1. Count 2. The court, having had count 2 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit Davion Flanagan, in violation of Ohio Revised Code Section 2903.02a, is charged in count 2 of the indictment. Count 3, murder. The court, having had count 3 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.02b, as charged in count 3. Count 4, murder. The court, having had count 4 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.02b, as charged in count 4. Count 5, felonious assault. The court, having had count 5 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit, Dominic Russo, in violation of Ohio Revised Code Section 2903.11 of the Revised Code, is charged in Count 5 of the indictment. Count 6, felonious assault. The court, having had Count 6 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit, Dominic Russo, in violation of Ohio Revised Code Section 2903.11A2, is charged in Count 6. Count 7, felonious assault. The court, having had Count 7 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit, Davion Flanagan, in violation of Ohio Revised Code Section 2903.11A1, as charged in Count 7. Count 8, felonious assault. The court, having had Count 8 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit, Davion Flanagan, in violation of Ohio Revised Code Section 2903.11A2, as charged in Count 8. Count 9, aggravated vehicular homicide. The court, having had Count 9 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of aggravated vehicular homicide, to wit, Dominic Russo, in violation of Ohio Revised Code Section 2903.06A2A, is charged in Count 9. Count 10, aggravated vehicular homicide. The court, having had Count 10 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of aggravated vehicular homicide, to wit, Davion Flanagan, in violation of Ohio Revised Code Section 2903.06A2A, is charged in Count 10. Count 11, drug possession. The court, having had Count 11 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of drug possession in violation of Ohio Revised Code Section 2925.11A, as charged in Count 11. Count 12, possessing criminal tools. The court, having had Count 12 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of possessing criminal tools in violation of Ohio Revised Code Section 2923.24A, is charged in Count 12. The court, having had Count 12 tried to it pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of possessing criminal tools, and further finds the defendant did intend to use a substance, device, instrument, or article, to wit, a digital scale, to commit the offense of a felony. Sentencing will be 1 week from today, August 21st at 1 p.m. If any party wishes to file a sentencing memorandum, it is to be filed by 4 p.m. on Thursday, August 17th. Thank you.
Thank you.
Love you, baby.
Everybody drinks this, please.
Today is the sentencing of the defendant for the purposeful and intentional murders of Davion Flanagan and Dominic Russo. And in a way, it's the second time their families are gathered again to grieve. It's also a day when Mackenzie's family will grieve for the future of their daughter. All three of these families and the friends of these families are suffering, and all of their lives have been irrevocably changed because of the actions of the defendant. The unintended and collateral consequences of a selfish, intentional, and cruel decision by Mackenzie will ripple forever in time. It's literally changed history because it's ended two lives. Two young men are dead. Their deaths were horrible, terrifying, and tragic. I will say again, if any reasonable person reviews Exhibit 802, there can be no doubt in your mind what happened this week. There can be no doubt of the absolute terror of the two people in that car. The defendant controlled all the events. She chose the day. Specifically, she chose a day just before her 18th birthday. She chose to drive the car, the time to drive the car. She chose an obscure, previously scouted route through an industrial parkway. She chose the target to hit and the victims. She chose the means and the method to follow through. And she planned and purposefully executed the events of July 31st, 2022. The review of the evidence supports the factual findings, the forensic testimony, the testimony of the first responders, the testimony of the emergency room doctors who treated the defendant, the testimony of the coroner's medical examiner, the testimony of those who knew the victims and the defendant, and the testimony of the BMV official who provided evidence that not only did the defendant deny any medical condition when applying for her license, which her mother co-signed and attested to, but also that just after the accident, Mackenzie renewed her driver's license and again denied any medical condition. In fact, the defendant was so concerned about driving that, as the state mentioned, during the investigation, she asked if they could just suspend her license for 10 years. It is hard to fathom how a person could be concerned about their driving privileges, having just been responsible for the deaths of 2 people. There was no medical condition that caused this as an accident. There was no mechanical failure of the car. The record is clear on the facts and the evidence. Her mother's uncorroborated statements without any medical testimony or records is not persuasive. It is also important to remember that even if Mackenzie intended to also die in this crash, that is irrelevant. A failed suicide attempt is not a defense to murder. And even in a murder-suicide attempt, when the perpetrator executing the plan survives, the other death or deaths are still murder. There's only one person who's responsible for the pain of everyone in this room, and that person is you, Mackenzie. Nobody else is responsible. This isn't the fault of Dominic's family, or Davion's family, or your family. And I know that each of you have asked your questions to yourselves, what if? What if I had done this or that? The truth of it is, none of us can control the intentions of another. And when there is a purposeful intent to harm or kill someone, it is the perpetrator alone who bears the responsibility for the choice and the consequences and the harm that follows. The difficulty for sentencing today, honestly, is whether or not I believe you should get consecutive sentences. I'm troubled that should I give you a concurrent sentence, that people will believe that somehow I'm being disrespectful to one of the victims. And on the other hand, I have to weigh the punishment. There's a very good likelihood, Mackenzie, that you will spend the rest of your life in prison. That won't be up to me. That will be up to the parole board, and that will be up to you to a great extent. I understand that the pain in this room wants me to impose the harshest sentence. But I don't believe that would be the appropriate sentence, because I do believe that Mackenzie will not be out in 15 years. So she's sentenced on count 2, the murder of Davion Flanagan, 15 years to life. She's sentenced on count 1, the murder of Dominic Russo, 15 years to life, to be served concurrent to each other, with credit for time served. I'll waive fines, fees, and costs, and your appellate counsel will be assigned. Are there any questions from the state?
No, Your Honor, thank you.
Any questions?
No, Your Honor.
All right, thank you.